Okay. Well, welcome everybody. This is the Zoning Board of Appeals for March the 9th, 2016. We don't have minutes, so why don't we get right into our agenda. The first item on our agenda is a public hearing on an application filed by David Paul Burns and Rebecca S. Bausch for 2 variances to construct a rear addition on the property located at 26 Bel Air Drive. Who will be heard on this application?
My name is David Burns. I'm the homeowner and the architect. So this is for a 369 square foot addition off the back of our house, where the current building is the existing house from 1925 is built 5 feet 4 inches from the property line. The extension, what we would like is to maintain that line of the existing house, just for the planning and massing of the house to make sense. It is within the, obviously, 10-foot setback required, and there's also the combined required setback of 25 feet, where we are at 17 feet if we add both the north and south, both sides of the setback together. So that's the reason for this. The 2 variances that are really as a result of the one. We have done the mailing, and we've actually got a letter from our neighbor to the north, who's the one that lists this position in support. If that's a public, I can share that with the
That would be good to have on file, and if you could give the building inspectors the cards that came back, because that is part of our record. It's nice that your neighbor is supporting it. I actually lived in that house for 11 years, many moons ago.
We bought it from the Sackett's in
Yeah.
2000.
Well, we went to one of the first Super Bowl parties ever at the Tackett's house, and they were great neighbors and great people.
Hosts. This is 15 out of 18. Post office says they hold ones that have not been picked up for 15 days. So we're
33 cents.
So the first notice was 200 based on the 18 listed that I sent originally. The second time I went back to talk about the ARB, I got the list and was requested to talk to Greenberg, which they gave me a list that was more robust. And we've sent all those out, and we're still getting those back to the ARB. That is 18 or 15 out of 18 that was received.
Would people like him to walk through the project more, or people have questions?
I would ask that of the letters that you received, or the notices, the confirmations that you received, I assume is on either side of you, were they?
Yes.
2 of them? Okay.
Either side, and our neighbors to the rear received it because they've asked questions. They had a little bit of confusion on the wording of the letter.
Okay.
They thought they didn't understand the side yard implications, so my neighbors to the rear were just worried if there's something close to the rear yard versus not.
And just for a point of record, what the dimension, you have 5'5" at the front of your existing house, 5'3" at the back of your existing house, and what will the dimension be at the back of the addition?
I believe it's 5'1".
5'1"?
Keeping, not parallel condition to the property.
Okay.
But it stays greater than 5 feet. The state code requires the fireproofing, so there's a note on there about the eaves actually being fireproof to 1 hour rating within that 5-foot zone.
Right.
The eve has an 18-inch overhang.
Okay. Anyone here else to?
Would anyone else like to speak on this application? Move to close?
Second.
I move to grant the variances as requested.
Second?
All in favor? And that's unanimous. Good luck. You've really done a lot of nice work on the house.
Thank you. It's a great street.
Yeah, it is. The next item on our agenda is a discussion on notice of appeal of determination of building official interpretation pursuant to section 300-23A of the Dobbsbury zoning code for 75 Main Street project. And who will be heard on this application?
Good evening, thank you, Mr. Chairman. My name is Seth Mandelbaum. I'm a partner with the law firm of McCullough, Goldberger, and Stout. Here on behalf of BRB Contracting LLC by Bart Black, who's here this evening. They are the contract ND for the property, so they don't own it yet, but they're under contract to purchase it. And we're here not for any variances at this point. We're here for hopefully a robust discussion on some of the difficult provisions in your zoning code that are a little vague, to be perfectly honest, and we've struggled with them, and we've been working through the process. I'd like to give you a little bit of background. As residents of the village, I'm sure you've heard about the project on many different levels, perhaps. It's been pending, actually, since last summer. And the project, very simply, is to take the iconic Oceana building on Main Street, which has been vacant, essentially vacant for a few years now, renovate the front building with residential units, with retail on the street level, and then take the warehouse building in the back, convert that into an indoor parking garage to provide off-street parking, and then create 3 levels above that for additional residential units. So Patty Steinschneider, Gotham Design, has been working on the project as well since last summer. And I think the easiest image to work off of and sort of speak from, and we have all the images that of the plans we submitted as well as some others, is the elevation, because that kind of shows what is contemplated. You have the Oceana building on the right, and then the warehouse on the left with the proposed addition above it. But I think before we get into it, what I hope will be a good discussion about the various points in the notice of determination from which we have appealed, just a little bit of background. This application was originally presented to the Board of Trustees last summer, and it's a very unique property. The front property is in the DB, Downtown Business District, and the rear of the property, as you go down Chestnut toward Palisade, is in the MDR2 zoning district. It also fronts on 3 streets, arguably Main Street, Chestnut, and Palisade. Sort of a transition from the downtown to mixed-use type neighborhood on Palisade with the Pompey Church and multifamily and single-family structures, the park, and you all know it as it goes down to the train station. So one of the things we talked to the Board of Trustees early on about was the possibility of rezoning the back lot to DB, to make the entire parcel, and it is one tax parcel, but it's in 2 zoning districts, uniformly in the downtown business zoning district. So that was one possibility. They said, okay, we'll refer that over to the planning board and get their input on that issue. And I didn't get involved until October. This was before I was involved in the project. Another issue that we've been working through and was discussed very early on is, okay, the existing building is non-conforming, legally non-conforming in many respects, not the least of which coverage, setbacks, and height. And there's a provision that was put into the code by the Board of Trustees in 2011 where a site plan could be built in a way that's potentially conforming, but you could have perhaps a better plan for the village, more in line with the intent of the zoning code and vision plan. Then the Board of Trustees gave itself the ability to waive provisions that normally might come to you as a variance. It's 300-52E. And we sort of started down that path with the Board of Trustees and spent many months in front of the planning board with input from the HRB. And ultimately, in the beginning of January, the planning board recommended back to the Board of Trustees that a majority of the planning board did not support the rezoning to the DB. which would have greatly reduced the number and extent of variances, but there still would have been one or two required, but less than were required for MDR2. But at that point, the planning board, with the input from Dwight Douglas, the village planner, and the HRB, recommended that the waivers requested be granted and the site plan be approved. We had a couple of public hearings before the Board of Trustees in January and February. We have not been on their agenda for a few weeks. But in the interim, Mr. Manley issued a determination. Actually, Brian Cook issued one in early January that was a little more general, and Ed issued one that went down the list of what, in his determination, the waivers and/or variances, if the Board of Trustees determined the waiver was not appropriate, should be. Under your code, even though New York State law gives an applicant 60 days to appeal a building inspector determination, 300-23A only gives us 30 days. So that's why the timing may have seemed odd. It wasn't really key to your normal filing deadline. We literally filed on the 29th or 30th day to appeal that determination. And although we think that some of the provisions are perhaps vague or a little bit tough to understand what the intent is, under New York State law, if there's any ambiguity, it's supposed to be construed in favor of the applicant. That's well settled New York State law for over 100 years. And I've had many discussions with the village attorney about some of these provisions, and I think on some of them we have some agreement, and other ones maybe not. So if you will indulge us, we're really here this evening because we filed late. It was not noticed as a public hearing, but we did want to perhaps have a discussion with you on these provisions, get a sense of the zoning board's feeling on some of these. And some of them there may not be an easy answer. A few of them we believe are pretty clear cut. So if I may, I'd like to sort of go through those and get this board's feeling on each one if I could.
Could we just step back a little bit?
Sure.
You know, you mentioned at the start that this has been pending since last summer.
Correct.
And I would think that you'd want to move ahead, you know, and
Right.
getting an interpretation from us doesn't seem like it's a step toward moving ahead. I would think, you know, either, you know, moving ahead to either get a denial or, you know, to get this thing out of the, out of where it's stuck right now would be a step forward. It doesn't seem like this gives you a step forward. It perhaps narrows down some uncertainties, but those uncertainties will still remain for you to overcome.
Well, let me
And-
respond to that if I could. Some of the comments we've heard in the public hearings, and there's, I'm sure you've heard if you've read the Enterprise or just followed and watched the meetings, there's a very vocal group, and if you look at the percentage of 11,000 people, it's a small group, but it's a very vocal group, opposed to not just this project, but I think development generally in the downtown. I think that's a fair statement based on the last 12 to 18 months and the applications that have been before the village. But a big part of the concern that's been expressed by the public, and I think by the Board of Trustees to some extent, is the extent and number of waivers that are required for this project. So our feeling was, first of all, I couldn't let my client let his right to challenge that interpretation pass without at least putting a notice into this board to preserve his rights, which we've done. Once it's use it or lose it, once that 30th day goes by. And I do think it would help, as you say, narrow the issues and perhaps focus the waivers that we're asking. If it was, instead of, right now, the determination says 7 waivers and a use variance. We believe it's more like 2 waivers and no use variance. To me, that's a huge difference in what we're asking the Board of Trustees to consider waiving in the context of what we believe is a much better site plan for the village, which really is the intent of that provision. And the village planner, in his memo to the Board of Trustees and in the recommendation from the planning board, really focused on the many benefits that the plan with the waivers has, not just for this applicant, but for the village as a whole regarding parking, tax base, the ability to have more residents with disposable income living in the downtown near the train station. I quoted them in my letter for your background, but there were much more extensive findings based on the 6 meetings we have with the planning board and a lot of work that was done by the consultant. So we really do feel like it is a step forward because it focuses and narrows the scope of our waivers in a way that we think makes the application perhaps more manageable for everyone that's looking at it right now.
Okay, I have a concern about the procedure that's going on here. This isn't our typical procedure, and what concerns me is that I think you have every right to file a notice of appeal, and it's probably the right thing to do to protect your interests. But the idea of putting this on before us today without notice to the public, and you're suggesting you're interested in our feelings about generally, which I don't think count for much, but I think they especially don't count for much in the context of a proceeding where we're only hearing from one side, where there may be, I don't know if there will be members of the public who want to be heard, but ordinarily, before we begin a discussion, or, you know, the entire discussion is one that's done on notice so that all sides can be heard and we can reach not just some off-the-cuff remarks about that sounds good or that doesn't, which I don't think you can actually put any reliance on. I'm just concerned about whether we're shortchanging the process by even allowing an opportunity for one side to make a presentation without notice to everyone who might be interested.
Well, I don't think you need to have a discussion tonight. I think we do this a lot at most of the meetings, planning board, ARB, and board of trustees, with a sort of a pre-submission, a statement of what they are gonna do and propose. Usually there's not a lot of back and forth. Sometimes there is at the planning board level, sometimes at the ARB level. Board of trustees really just takes it in and then schedules the public hearing. So the thought was that you could see, understand the issues, what they're proposing. You probably aren't ready to start a discussion back and forth because there haven't been, Ed has a short letter to you, an updated letter, once you just received some recent documents from the applicant. So the plan was that they would present, if anyone had any questions for us, we could answer them, but the plan was then to have a public hearing, and then you would have a more detailed response from the building department about the specific issues.
But there's been no indication, though, from the Board of Trustees whether they intend to grant waivers or whether they intend to bring this to, let this come to the ZBA. Is that correct at this point?
They haven't formally said anything. That's
Okay,
correct.
so wouldn't this discussion, though, at this stage, be better brought to the Board of Trustees?
They're trying to narrow the waivers.
They are.
Right, yeah.
Yes,
I
and we
figured that was
appreciate
the-
the opportunity. You know, I understand your concern, and Derry said, and we've spoken about this, and frankly, I thought we were late for this meeting, but we talked a little bit, and Derry said, you know, why don't you come present, so at least the board will be informed when you get to the public hearing about some of the nuances of each of these items. So we would very much appreciate, we're all here, my client's paying for me to be here. If I could just take you through the list, if you don't feel comfortable responding,
You will need to present on the record in
understood.
the public
Of course.
hearing. Also,
It's a public meeting,
yeah.
but it's not the public hearing.
Can I
get
ask you to
that.
start though with a macro question about the waivers?
Absolutely.
Basically, I agree with my colleagues that this is unprecedented and probably not right. But if I look at the list of waivers you're talking about, you can see that they all really stem from a common reason, a common cause. There's one macro issue that causes 4 or 5 of your waivers.
Mhm.
And in order to rather than looking at them incrementally, could you present to us what is that one macro issue which is causing 4 or 5 of your waivers to result, which is obviously something that probably isn't a decision we're authorized to make it under the code. We're talking about the fact that you've got 0 feet in certain areas, because of pre-existing
Yeah,
issues.
those are existing non-conformities.
So could you explain where you are in your position versus the position opposed by the opposition on that series of issues?
It's not quite that simple, to be honest, because within the
Let's make it
nonconformities,
simple.
there's different categories, which is why I suggested if you could let me just sort of go down the list. In fact, I'd like to start, if I could, with what I think is the most clear-cut one. And again, this is by way of additional background to sort of elucidate my letter that was submitted to meet the deadline, the 30-day deadline, not your deadline, with the understanding that we have to have a public hearing next month. So if I may, I'd very much appreciate the indulgence, and I'll come back to your question if I could. The one issue that to me couldn't be more clear-cut, and some of these I think there is a lot of vagueness in the code, is that the back building that's proposed above the warehouse, the determination of the building inspector says that to have more than 8 units, we need a use variance. I frankly think both your code and case law would suggest otherwise, because we are not asking to build a use that is not permitted in the zone, which is what a use variance is for. The issue actually goes to the density, and although the description of the MPR2 says you can only have a maximum of 8 units in the MPR2 zone, in the definition of area variance, it specifically says that, by way of example, area variances are for things like parking and density. So that one, to me, is sort of an easy one. And I gave you a case from White Plains, where I had a client who had an analogous issue, and the court found in our favor in that case for the building department had a similar determination. But it was a criteria of a use, and the building department said it was use variance, if we didn't meet that dimensional criteria. So that's sort of the first one. I want to skip to that one if I could, and then I'll come back. And if there are questions about any of these that you're comfortable asking, of course, that's why we're here. If you're not comfortable this evening, we very much appreciate the opportunity to just present the various issues. So the second issue that's not directly related to the macro issue that Mr. Gamos referred to is parking. Again, another very complex issue, particularly in the downtown. So we agree with the determination where it opines that the retail proposed would not require any additional parking under the code. However, there's 2 provisions that at first blush appear to conflict with each other, but I don't think they really do. There's one provision that talks about parking for additional residential uses on an existing lot or a newly created lot. Then further down, it talks about change of use. And you have to look at the most recent use of this building, which was office. And when you compare the requirements for office to the requirements for residential, it does not hit the threshold for requiring additional parking spaces for any of the residential, other than the units in the back. So even though it may not seem like a very important issue, it actually is for the overall use of the site. And on that one, we'd like you to consider a modification to that determination that only 1 space per unit is required for the proposal for the rear property, where the three levels above the garage are proposed, the warehouse, which would be a garage. And just by way of additional note, we would be providing well in excess, as noted in the determination, even if you counted 1 space per unit plus space for some of the retail. In fact, our last submission to the Board of Trustees, my client has indicated he's willing to put in lifts on 2 of the spaces, which gets up to 30 off-street parking spaces for 22 units, and have the ability, perhaps, build it so even more, 14 additional lifts can be put in if there were unit owners of these, what are contemplated to be condos, had 2 cars. So we're really trying to be sensitive to the issue of the problem, particularly bad in downtown Dobbs Ferry with on-street parking. We've been in discussions with Father Scannell at the church, and he has concerns about that, and he's expressed in public hearings, but we're comfortable that we're going to be able to resolve his concerns based on our last meeting, and these lifts is one way that they might do that by adding a lot more. Even we're already above what's required, but yet adding even more off-street parking to pick up some of the retail parking as well. all of the other issues do relate to the macro issue that the building that's there now is dimensionally non-conforming with regard to lot coverage and the various setbacks. But as I said a few minutes ago, each one's a little bit different, so I'd like to just go through those one at a time. With respect to lot coverage, we're not increasing the lot coverage at all. We're building above what's already there, but lot coverage is footprint over lot area, and we're not changing those numbers. So there are two waivers in the determination that say we need either a waiver or a variance for lot coverage. We would ask this board to eliminate those two from the determination, which of course you are empowered to step into the shoes of the building inspector under your code and general city law, which is why we've made this appeal. With regard to setbacks, this is where it gets kind of really tricky, because it's a single tax lot, it's a single building, but again, it's in two zoning districts. One could argue that Main Street is the front and Palisade Street is the rear. That's one way of looking at it. But another way of looking at it, that the building department has taken this tack, and Dwight Douglas did as well in the planning board recommendation, is that Palisade you have to look at as a front as well. And we're willing to go down that road for consistency's sake. So when you do that, there is a provision that allows you to take the prevailing setback in the area, and we've submitted an exhibit, and Patty has reviewed it with the building department. And based on that provision, as well as the fact that what is proposed above the warehouse is actually stepped back, such that the closest point of the addition is actually 15 feet from the property line. The existing warehouse is 9'4", which is the existing non-conforming. When you look at the prevailing, it's 11.7 feet including the building, the existing building, or 12.9 not including the building, but either way, our 15 feet is further back than the prevailing, however you calculate it. However, the determination said we do need a waiver. We disagree, and we would ask this board to eliminate that one as well. And I know that in the March 2nd memo, there was an adjustment to that, but still said we need the waiver, which again, we don't think we need a waiver at all because of what we're building above being conforming. And there's a section of the code that Darius and I looked at today regarding non-conforming uses and non-conforming bulk. It refers to a special permit for a change or enlargement of non-conforming use, and then says you don't need a special permit if you're conforming. It doesn't really tell you much beyond that. But again, I think it has to be read in the light most favorable to the applicant where it's ambiguous. So that's when we believe no waiver should be required. The same goes for the rear yard setback off of Palisade. It's one zoning lot, so when you look at the definition of rear yard, there is no rear yard going from Palisade back toward Main Street. But in that case, the determination said we do need a waiver or a setback there as well. And if you determine we do need a waiver or setback, we believe it should be 20 feet, not 25 feet. But again, our initial position is that we don't need that waiver either. We do agree on Chestnut Street. It's zero lot line right now. We're building above it at the 0 lot line. 10 feet is required, so we agree that one. We do need either a waiver or a variance because it's in line with what's already non-conforming. So that one, we agree. Same thing with the requirement to have 20 feet total for both side yards. We meet the side yard on the other side, the far side of the building from Chestnut Street. When you add up the total, it doesn't provide the total of 20 feet. We have 16'9", so we're about 3 foot 3 inches short there. The final issue, and again, this one, I've saved the most convoluted one for last, which is height. Again, if the Board of Trustees had been inclined to rezone the property DB, at worst, And there was one planning board member, by the way, who did support that and actually voted against the resolution on the recommendation. Even though he supported the projects, he voted against the resolution because he felt the Board of Trustees should have considered rezoning, but the majority of the planning board did not feel that way. And the feedback we've gotten from the Board of Trustees so far that they're not really inclined to consider that, which is their right, it's a legislative act. But we disagree with the determination, particularly with respect to the penthouse. Again, there's some conflicting language in the exception for penthouses in 300-34C 1 and 2. In section 2, it does refer to penthouses. In section 1, it doesn't, but it refers to bulkheads. Dwight Douglas, and he's not the building inspector, but he is the village planner, in the planning board recommendation noted that you can have a penthouse that's used for things other than mechanicals, in this case amenities, as long as it's not livable space where somebody's residing, which is not proposed here. I see why the building department took the position they did, because I think that there is some ambiguity there that if it's not being used for mechanicals, then it counts. But again, we feel it really should not be counted. And just as a footnote on the height, there's another anomaly in the MDR2 where a flat roof, you're only allowed to go to 30 feet from the grade plane, but a pitched roof, you can actually go 40 feet to the midpoint. And I think, Patty, you included that exhibit, right, in our package, which shows that if you went 40 feet to the midpoint, although we believe it would be not the most appropriate architectural design, it would be almost as big as what we're proposing now that requires waivers. So it just goes to show that there's some issues with the MZR2, we believe, and the waiver provision was really intended to give the Board of Trustees some flexibility where there's a unique project that has a lot of benefits to the village, they can take the step to grant the waivers. So I know this is very long-winded, I know it's very convoluted, but this is why this board, one of the reasons you exist, is to look at issues just like this. And we do appreciate your time tonight. I know it's not your normal practice to informally hear an applicant, but the timing was a little strange because of that 30-day clock, and because we've been sort of going through different processes with various boards. So we very much appreciate it, and we are happy to answer any questions the board would feel comfortable asking this evening, or we can come back for a formal public hearing at your April meeting if you're so inclined.
Just one question.
Sure.
Do you, your architect and your client agree that this is a discontinuation of a non-conforming use?
No.
Because it's been vacant for the last several years.
Which non-conforming use are you referring
Well,
to?
we've had issues in the past where we've had a property, most of Dobbs Ferry does not conform to the current code. We have many instances of that, because buildings and houses were built before the code was in place, so we don't meet setback requirements, say, as a simple example. And as I understand what you're saying, Oceana's original construction is, as what we certainly see, it does not meet the current code in numerous instances. But generally speaking, and I can't swear to the latest edition of the code, but in the cases we've had over the last, they say 10 to 20 years ago, if an applicant would come and he or she would make the case that they want to continue to have the same benefits of the former property owner had, but the property had been abandoned for a period of years. And in those cases, those benefits didn't accrue automatically. It wasn't, because you had discontinuation of the non-conforming use.
Right.
And essentially, as I heard you say, Oceana's been vacant for the last several years. So do you get a situation where any consideration of this as having been a continuation of a conforming use and allowing you to not meet those setback requirements, it essentially becomes lost because of that discontinuation?
I don't believe so, because we're not asking to continue a non-conforming use, we're asking to continue a non-conforming bulk. And I believe that provision only applies to non-conforming use. I will check that and we can take a look at that. But the building is the building, and last use was a conforming use, it's really the bulk of the building that is not conforming. So my understanding of that provision is it only applies to non-conforming
Uses,
uses,
not
you know, the
areas.
classic junkyard in a residential zone is sort of the poster child for that provision. And if it's discontinued for some matter of months that's set forth in the code, then it can't be reactivated. I think that's what you're referring to.
Yes.
But,
Yeah.
we can double check that certainly.
There's a year provision, Mark.
I believe it only goes
Yes,
to use there.
it's a year.
Yeah.
That's for abandonment,
Yeah, the question is, I think,
that's not what this is.
do you have, I know there is some use in the Oceana building, are they still
It's
using?
it's office, right, essentially.
Which office would that be?
Yeah, just to, I'm only gonna respond to this one quick thing, because I'm not supposed to talk.
That would be very difficult.
I know, it's tough. The contract ND is buying the building from the previous owner,
Right.
who went to the village of Dobbs Ferry and got approvals to renovate the building and create residential units in the building and do other things with it.
In the front.
In the front building. So he started that work, he had building permits, he moved to a certain point. It has moved very slowly for the last year or two, maybe longer.
Permits are expired,
It was
never
permit, yeah.
finished, never brought to the CO.
Right, when this process started, we agreed to that status of it. But at no point has it been abandoned, and at no point has it been considered a discontinued use. If you look at the code in Dobbs Ferry, we actually changed that in 2010, so that we specifically made it clear that I think the example we used was, if I have a beach house that happens to be non-conforming dimensionally, and I don't use it for a couple of years, have I don't go and stay there for a couple of years, have I lost the right to stay in the beach house? If I had a non-conforming use that said I was, renting it out for a use that wasn't permitted, and I abandoned that use, then it would be a different thing. But the use is conforming, it's compliant, it is only the dimension, and the thing I wouldn't want to see is the suggestion that because one of the things that's been very clear in all the presentations from the community is a strong concern with what happens with the existing structure and how that's restored. So the idea that when we solve all these problems, is take everything down and build something conforming, would probably not be a great direction.
That was in the direction I was headed, but you did answer the
Thank God.
question, that the issue is not, the issue of discontinuation is strictly limited to the use function and not to the footprint function.
The code talks about use, I think we gotta look at something, this is why this is a good discussion tonight. We can look at that in the case law, how it analyzes it. Our code does say non-conforming use that is abandoned. Doesn't talk about area or bulk, but we can look at some common law and see how it's analyzed too.
Thank you.
If you want me to say more.
Can you explain your understanding of why the planning board chose not to entertain the rezoning of the
Sure.
Palisade lot?
I think there was a concern on the part of the planning board that if this project didn't go forward, or the building was developed and then sold, because there are different uses in the DB as opposed to MDR2, that there could be something undesirable developed in the future under DB zoning as of right. And there were a lot of discussions about it. And that's ultimately where the majority of the planning board fell out on that issue.
That's correct, that's what they, no.
Okay. Okay.
There's nothing we can do about it because it's a legislative act, and that's the pleasure of the board of trustees.
Right, okay.
So it almost strikes me that this is all about cosmetics.
I don't know that it's about cosmetics, the building.
Well, in the sense that, the property that was before us, came for a side yard variance, where the house was built too close, to the next door neighbor. They wanted to do a nice addition. It was extending the building along a non-conforming line, and it was really an attractive way to expand the house, but it required a variance. Now, that's a variance that is pretty insignificant. It wasn't harming the nearby neighbor. It's routinely given. There's probably no project in downtown that doesn't come to us for a variance. Why? Because the code was written before these buildings were built. And, it almost seems as though we're equating numbers with severity. And, it just kind of has absolutely nothing to do with that,
Well,
necessarily.
I understand what you're saying. I respectfully disagree from the perspective of, A, it should be right, just as a matter of having a law that is governing land use. I think that's important. And secondly, and more importantly, a lot of the discussion at the public hearings with the Board of Trustees, and there are other issues, of course, that were discussed and brought up, and we've submitted a lot of documentation responding to many of those issues, and whether those responses are acceptable or not, we'll find out. But a lot of the discussion has centered around there are too many waivers, it's too much. And there's no right line, because the waivers are discretionary, and the whole idea of giving the Board of Trustees, giving itself the ability to waive provisions of the chapter, were to create a better project for the village. It's right in the code, right in that provision. They may ultimately, at the end of the day, say, you know what, we don't want to give you waivers. Go get variances, and if you can get variances, come back to us, and then maybe we'll approve it, maybe we won't, it's still a site plan approval. But we felt that would kind of be, not the easy way out, but would sort of not complete the intent of the process of having the waivers in the code. So we would like the Board of Trustees to have a list in front of them that we hope is as focused and accurate as it can be under the words of the code. Again, acknowledging that there are some ambiguities, which is why there's this safety valve of the zoning board to look at the legality of the words and see how they should come out. I'm not suggesting some of these are easy, I think some of them are very difficult. But that doesn't mean we shouldn't go that extra mile and get the list pared down to the minimum amount of waivers that are required for what we are proposing that's still pending before the Board of Trustees. So I understand what you're saying, the building is the building.
Right. What I find kind of ironic here is that almost no project that comes before us from downtown can provide a single parking spot, and this project provides many.
And that is one of the biggest benefits of the project noted by the planner and the planning board.
But there is, the analogy you were given about the side yard and the variance we approved previously. There is a big difference in this one, in that this one touches two perennial hot button issues. It touches height,
yes.
and it touches the corollary of height here. And I think if we would have a serious discussion with you on this project, on the record, after notice, those would be things that I would want to hear addressed.
Okay. And let me just address that briefly. The reason we didn't give you these 5 iterations of SketchUp model that we've gone through with the planning board and board of trustees was because we're not asking for variances at this moment. So we can give that to you by way of background, and we're happy to do so, but it's not necessarily relevant to the task before you at the moment, which is looking at the black and white words of the code. Of course, it's a project, and that's important context, but that, if you're wondering why we didn't give you those visuals, that's why. And we have them tonight if you want to see them, but we can certainly present them at the public hearing. But that's why we didn't. I really thought this should be focused on the black and white of the statute and the bulk table and the determination and how those things play with each other. And there were a lot of different iterations leading up to the one the planning board was comfortable with input from the HRB at the beginning of January. And there's been a further iteration responses and public comment. But every time, we've stepped back several pieces of the building, made things lower, tried to keep the architecture interesting, and not just have a box back there, and really have, the architect is very well known in the region for his work with old buildings and bringing them back to their former glory, and that's part of the project in the front, is to get that Oceana building, which is over 100 years old. He can do things that are not required because it is not listed as a historic building, but we're proposing, and our client is going to spend the money on this overall project, if you can make the project work financially, to bring that building to a very high level of restoration. So that's another benefit that was touted by the planning board of this project, which really ties into keeping the warehouse, providing parking so they can be marketed as condos, having units on top with nice river views. All these different things are connected to this project working financially and working in a way that these benefits can be provided to the village. So it is all connected, and we're happy to provide some visuals at the public hearing.
One more. A question for Mr. Cook and Mr. Manley with respect to the analysis about parking spaces. It strikes me that analysis is a full lot analysis, one lot, one project analysis. It's the whole building. It is 22 or 24 units, one space per dwelling unit, and that was the approach of the analysis. Is that fair to say?
Yes, what Mr. Mandelbaum was talking about with pre-existing and gaining the requirements from the pre-existing for parking refers to commercial. And we took the commercial as existing and didn't require any for the retail space.
Right.
But in 348, it refers to residential use, and parking standards in this chapter apply whenever residential units are added. And we went back to the parking table to find out we need one per unit.
Mm-hmm.
And it complies.
Yeah, it seems like the counter to that from the applicant is a half lot analysis. They go back to the half lot analysis and look only at the Oceana building and say, because of the previous use as office space and based on a square footage analysis, you can't count that building in counting parking spaces.
If the Oceana building was still all office building,
Right,
we wouldn't.
right. No, I'm just wanted to clarify, because it goes from because the rest of the arguments are about, items 3, 4, 5, 6, and 7 on your letter. The counter to those arguments is the one lot, one project analysis, right?
Because the bulk of the front portion of the building in the DB is all existing and not being changed.
Mm-hmm. Right.
I think parking, if I may jump in, parking is compliant as far as you're concerned.
Yes,
But the issue of parking, I think your question was, that's sort of thought of as one lot when you're doing the parking analysis. I think it could be looked at that way, but also it could not be. It's not necessarily, he's looking at the project as a whole and saying there are enough spaces for the whole project.
Right.
And the code talks about sharing spaces, but there are, and potentially, let's say there were two different owners here, the two lots, that would probably comply even if there were two different owners and they were on one lot, because we would need a shared
Right.
agreement, but here there happens to be one current owner, so.
I would
They
think-
are gonna be connected. I think the one issue, the rear lot, there are two zones here, to the MDR 2 zone and the DB zone.
To me,
So
that's the big question, right? One project, one tax lot, but it
Two
is
zoning lots.
it is bifurcated, and the planning board upheld that, so it's an interesting.
Yeah, I think the
It's an
analysis
interesting
was two
problem.
zoning lots, that's why you did the rear lot setback.
I would have thought the parking would have been a non-issue, but the applicant, countered it actually, took an amount of energy to do it, so. I just wanted to get clarity on it.
No, I understand it says we're compliant. To be perfectly blunt, our client has a lot invested in this project and is not sure how this is all going and wants to have options. Do perhaps a different type determination. And the way I read it, yes, there's the section about residential units, but then the next section talks about change of use. And doesn't limit it to change from one type of use to a different kind of use. So I think there is some tension there in that section of the code. So I think I think it could be read either way, but that's for this board to decide.
Darius, go ahead and follow up on John's comment. I think it's an interesting point he's raising about one lot, two zones, and just curious whether there's any case law which talks about that issue and whether, and how it has been decided in the past in terms of does, what takes precedence, so to speak? Is it by square footage? Is it by, is it treating as separate entities essentially, which creates some of the complications? Is there anything we can look to historically which might give some clarification that may support or not support the planning board's opinion on this matter?
I don't have the answer for you tonight, but I'll look into it. It's very unique. I haven't run into it before. We've had.
I have as an architect and on projects, and I don't necessarily want to go through what got determined then, because I don't know if that was right or wrong. It was just a determination.
What we did. I think there's three. I think we talked about there were three properties in the village that were in two different zones. One of them was the Rudy's property. It's a little bit in the EI zone, and the MDR1 zone I think is 90%. So we applied the MDR1 in that analysis. This is really 50-50. So I'll take a look.
Thank you.
I have seen codes that specifically say, whichever one you're the majority, it says what you just said, then you apply that one.
And actually, that's how it got decided. It was an issue in the hospital and a residential area, and health was spilling over and how we treat it.
And it goes back to why we asked for the possible rezoning to clean it up, because it's such a unique lot, but I understand also the arguments for not doing it.
The MDR2 may be larger.
We can confirm
We'll
that.
look. Yeah, we'll look at it. It's a
Just
good question.
guidance.
Yeah.
Any questions about variances versus waivers?
Why would we bring
It's still getting fascinating.
it? That's not,
That's not
before these board.
Nobody cares.
We could do a little homework on the questions you had, maybe provide a little response analysis
Thank you.
from their letter
Yeah.
of February 25th. I know Ed did a good job on the 3-2 letter of 2016. We'll try to do a little more, so you have everything you can with the code provisions there, so you can compare them and look at them for the next meeting.
Yeah, that would be helpful.
Yeah, so we'll do-
Because we need to,
Yeah, we'll have exhibits for you so you can know what code provisions are being cited, because when you look at this, it's, I don't wanna look through the whole book. I even brought my book tonight. Ed's got his computer out.
When Peter and I first started doing this together, the book was only this big.
I would like to make one.
Thanks for the reminder.
Just one final comment on the 3-2 memo, and this is a statement against interest, so to speak. The height there was actually changed to prevailing height, and it kind of goes to your point, Chairman, that, you know, the numbers are the numbers, but the building is the building. I'm not sure that prevailing height applies in the MDR2, so even though it means we need a bigger waiver, I'd rather have it right. So I think actually, your original memo may have been accurate with the code, even though the intent, when you read the whole thing, the intent might seem like prevailing height should apply in the MDR2. I couldn't find anywhere in the code that it says it does. If somebody can help me, then find that, Jared, if you
We'll look
find
at
it.
we'll look at
But I don't want it to be incorrect, even though it's better for my client and throw something at me. But at the end of the day, if we need a waiver, I want to get the bigger waiver if there's any question, but also the right waiver.
We'll look at
So I just wanted to put that out there as well.
right, yeah, and if anything further comes up, you know, deal with the building inspector, and, you know, in the public hearing, we can address what we should be addressing.
Understood.
Should we,
Nothing to do.
what do we do? Do we continue this or close
Do you
it? I
think
mean,
you're ready for a public hearing?
I would think the next time, sure,
Yeah,
yeah.
let's do- yeah.
So just continue this and.
We'll notice a public hearing for the April date, April the second Wednesday, if I recall.
Second Wednesday, yes.
Which will be April 13th for a public hearing. We'll send out to the paper. You gotta do the the green cards, all that stuff, so, and we'll have a public hearing that night. But okay?
Sure. Is there any indication from the Board of Trustees about when they may make a determination? about
We're
which way
having
to
a
go?
work session on Monday. Some of the ARB members are gonna be there also at 6:15 here at Village Hall. No, Vinnie, no indication yet that there's any decision going one way or the other specifically, but the applicant asked for a work session, and the board agreed to do that to look at potential alternatives potentially are being discussed also, so.
Thank you.
For my clarification,
Sure.
I'm not, we can get variances. I'm not clear that we can give waivers.
No, the
No, we
issue
can't.
of the waivers, just so you are, our code was passed, there's a section, and it follows, I think it was a fourth department case, and state law, that says that the Board of Trustees can legislate that a planning board or them in site plan, instead of having to go get variances, they could waive certain provisions
So
of dimensionally.
what you're saying is what I thought you would say, but then what is the purpose of having a public hearing prior to the board determining whether or not it's going to provide waivers or not provide waivers?
Because they want to know the extent of the waivers.
And even if they
That's
ultimately say they
sort
don't
of
grant
like-
waivers, those would be defining the
How do
variance.
we know
No,
the extent of the
because
waiver?
the Board of Trustees, they don't want the Board of Trustees to apply on, for example, I'm making it up, let's say there's a 50-foot height waiver required. If they think, and they say no, they could, and they think it's a 25-foot height waiver. So they think maybe if it's a 25-foot height waiver, the Board of Trustees may say yes, as opposed to a determined, and somewhere in between. I'm not saying
Then
those
does this need
numbers.
to be recrafted as a series of variance requests for us to consider it?
They haven't asked for variances.
Only because we still have a waiver request.
That's my point. How do you come to us asking for us to adjudicate anything if you haven't translated your waivers into either yeses or nos and variances? Because we rule on variances, we don't rule on waivers.
I know, we're not asking.
So you rule on
Yeah, we're not asking for-
interpretation
But we
of
do
the code.
rule
You have
on
the power to
interpretations of the
interpret.
code.
And we did ask in that first letter.
Yeah.
Our first letter asked for it.
I'm not sure if
Yeah, you're
I
in
fully
power.
agree.
I can
I'm
provide
not
some.
sure either, frankly.
I can provide something, it's pretty standard, that's basic land use 101 for zoning boards. All decisions of the building department, for instance, the building department says, you know, the applicant, you need a 5-foot variance. The applicant could say, no, I don't believe I need any variance because of whatever, X, Y, Z. So the building department says you need a variance, they don't come, a lot of times they would come, there'd be a dual request. I'm disagreeing with the code interpretation by the building inspector and filing an appeal, and if they're right, I want a variance. They're doing part one here, they're not required to do part two ever, I mean, because they don't have to go forward with the project, but they're actually doing part one and having the alternate route for the waivers to the Board of Trustees.
I think for the benefit of our board, we need to make sure Jeremy and Paul are here for that, who are our two lawyers.
What I'll do before is provide you something with their analysis. There's actually a New York State Department of State pamphlet. I can email to everyone. It's pretty quick read. It's like 18, 20 pages for the zoning board that has a little section on this.
Okay.
I'd love it.
That
That'd be
be
great.
helpful.
Yeah, it's a good guide anyway for everything. They have them for different things, zoning board, land, everything. So I'll email it to them tomorrow.
And
Can I ask the applicant, Seth, you mentioned that well, you disagree with everything, but the front setback, saying that the new portion is what counts. So, you know, the base is what it is. So the extension of the nonconformity is what we need variances for. So you're saying that the new portion, the extension, is set back from the base, from the front setback. When I reviewed this, I didn't see that on the plan. So if Patty would, and I see it in your elevation,
Right.
but on the site plan, if you could layer the new portion on top of the existing and give me dimensions, because there's no dimensions there for me to
Right, this is just
calculate
calculate
that.
I think it's on one of the
Yeah,
areas, you know, the
What we
words on
did,
it.
because we agree with you that it's incredibly complicated to really figure it out. So what we did was this sheet. So we showed at each level where the existing building was and where we were setting things. So for example, here, you're seeing 9'3" and 5 feet. That's the closest we would be with that. Now, if we need, I think that actually complies
Okay,
with it. So this is the sheet that I
and
think,
we've got,
you've got this.
all right, I'll
And
take a
if you
look
need
at
more
that sheet.
copies of it, let me know, but I found it to be very difficult because what are you measuring to?
Right.
You
You
know?
could provide that to us?
Yeah, we've given this,
Do you have
before.
that?
Is that part of the set?
Yeah.
Design work? It is.
Okay, let's see, but okay.
But we'll be doing a new submission anyway, so I'll make sure that this is all in it. But this was very effective at demonstrating was a lot of the work that the planning board, the architectural review board did in terms of shifting massing away from the Hartnett House and to the corner, just so that people understand it. The massing that we've ended up with was not the applicant's massing. What we did is we put something together, we went to the board said they don't like this, they think we should do this, we tried different things. In the end, in workshops, what we came up with was the design that the planning board and the architectural review board preferred.
Steps
Which is the
back.
applicant.
And that's why, just to finish that point, I said on Chestnut Street, we agree with you, because it's 0 feet, what's there now, and we're just holding that
I'll
up.
take a look at that Palisades Street again.
Yeah, that's where it really was stepped back.
Okay.
And the original plan wasn't, so the one from last summer wouldn't have complied. But as Patty said, as we worked through the process, in trying to reduce the massing, as viewed from the surrounding area, it had the dual benefit of stepping back beyond the prevailing setback, as viewed from Palisades Street. Again, we very much appreciate your time. I think this was a very helpful discussion, I know, for us.
Good.
And,
Yeah, I think we made some progress, and
Yeah, and
we'll,
be in touch with
we'll see you next time.
Village attorney and building department on some of the other issues as well. Thank you very much.
Move to close?
Second.
All in favor? Everybody.